Hi, everybody. Welcome to the January edition of the Third Fridays podcast. New year, new us, new pod. First of the year. It's been more than a couple of years of doing this. And the funny thing is every time I bring this guest back on the show for a podcast, I get so much love that I want to get him back on. So this is like a double dose of a little Major Monday for everybody here. We are live from the Kill Room with my guest,
Christopher Major.
Do you like saying your own name?
I do not.
No,
I
that's
don't.
why I did that.
I don't care
on
for
purpose.
It's a good thing to put your podcast guests on their heels right at the outset.
Oh yeah, make them feel super comfortable because what we're going to get into is a little bit more of a 201 level discussion of the Civil Team podcast or webinar really that occurred earlier this week, right? So can you say maybe in 2 or 3 sentences, I know it's very tough for you,
Very.
what the 101 level webinar was earlier this week?
So it's about a very hot button topic in the world of workers' comp, the interaction with New York's no fault law. And there's that $50,000 carve out that every adjuster has had to deal with at some point. And the context of the webinar was, number one, ways around that, how to cope with it, and number two, loss transfer, how we can get that $50,000 back in some instances.
So let me play the shoes of your average risk professional or adjuster, right? Because what happens is a third-party plaintiff attorney is going to come to me and say, motor vehicle accident, $50,000, and I think it's actually quite reasonable for them to listen to that because it's supplemented with like statutes and case law that we don't get the first $50,000 back, right? Would you say that's a fair memorialization of how that situation plays out at first?
For sure. And I mean, especially because as, workers' compensation defense counsel, we frequently wield the workers' compensation law as our own personal sword. The knowledge of the workers' compensation law is your best chance at prevailing over an ignorant claimant's attorney. And unfortunately, it does us in this instance. Section 29, the subrogation statute in New York, literally has a subsection, 2 subsections actually, 1A and 2A, that say no $50,000 lien in motor vehicle accident cases.
We could get a little bit philosophical. Why would the legislature, put this out there? Why would they carve this out, so to speak?
So this is kind of a little ethereal kind of topic. Essentially, it comes down to the injured worker becoming their own self-insurer. So, let's say they get in a motor vehicle accident, right? And they have their $50,000 in basic economic loss coverage, and that's where the $50,000 carve out comes from. But the workers' compensation carrier is paying benefits in lieu of first-party benefits because workers' comp is primary to no fault. But they're entitled, let's say there's no $50K carve out, right? And they're entitled to they're entitled to a lien on that money. Well, then what exactly is the claimant's no fault coverage, right? He gets hurt, but that $50,000 that he would get in comp, the comp carrier gets back from his third party settlement. So for that first $50,000 that no fault is intended to cover, the claimant is a self-insurer. And there's Court of Appeals cases out there. There was one matter of Granger v. Erda, I believe it was, that even drew to the attention this harsh unintended result is how they phrased it. But that was the problem that the legislature needed to address.
So I can kind of understand that on a granular level, right? But to me, the problem is really based on the fact that what if you have the workers' compensation claim filed to really prevent the claimant from being his own insurer or a self-insurer of his own treatment, really, because that's what you're saying, right? The more contemporaneous and immediate treatment is so important to the claimant in a motor vehicle accident, right? And we don't want him to be self-selecting or be responsible for that treatment, him or her, right? But if the workers' compensation claim is filed, right, you now have a primary entity to pay for treatment, and that's where I think the foundational reason for coming up with this statute kind of falls away spiritually from a practical application of a certain type of case. Does that make sense at all?
Yeah, I mean, what it comes down to at the end of the day, though, is this first $50,000 is intended to apply without fault, hence no fault, right? So they don't want insurance companies bickering over the extent of liability or who's on the hook for payment or anything of that nature. So the fact that the claimant would then be in this situation of saying, well, now wait a minute. If I go out of work, I may get $2,000 per month under no fault coverage through workers' comp, but then they're just going to get it back from my third party settlement. So what no fault coverage do I actually have? It kind of makes sense, But I mean, there's still the cost of litigation reduction and everything. But I see what you're saying, that if they're being compensated and if they're receiving necessary medical treatment from a claim they themselves filed. The only issue is we represent carriers, and as when it comes to carriers, them's the breaks.
I think that it has some kind of application in a typical course where, right, we don't want people fighting over payment to prevent the rendering of treatment. But if there is no issue with the rendering of treatment, then I think it's okay to actually have discussions over which carrier should be liable and which should be reimbursed, because you don't really face the reasons why the loss transfer carve out is really applicable. But let's get into it. I mean, that's really a topic for our next year's podcast, where we see if there's anything moving in that philosophical direction. But with loss transfer, what we want to go after is two different things, I think. And correct me if I'm wrong, but either we look for pieces of that initial $50,000 that can actually be reimbursable through Section 29, or the actual loss transfer arbitration recovery itself, right?
Right. So the best way to think of it, and the way that I typically explain it, is you have two different kitties of recovery. If loss transfer applies, which 6,500 pounds unladen, any vehicle in the accident over 6,500 pounds unladen, or a livery vehicle, principally for hire for the transportation of people or property. If loss transfer applies, you have a direct right of recovery, a separate right of recovery distinct from Section 29 against the third-party defense carrier, which ordinarily would not exist. And you can haul them into arbitration after you serve the intercompany reimbursement notification and go after it that way. So that's kitty numero uno, right? Your $50,000 via this separate right of recovery under loss transfer. Then anything that's not subject to the carve out, and so in excess of 50, or in excess of $2,000 per month in indemnity, or indemnity paid more than 3 years after the date of loss, all of that's Section 29 money. So you're getting back your approximate 2/3 on it. So there's lien on third-party settlement, and then there's the $50,000 arbitration claim, is the best way to look at it.
Right. So let's start with the actual recovery through loss transfer arbitration and all that, right? Would you say it's a good idea for carriers to maybe use that $50,000 number as almost like a trigger or an alert to say, now I should go pursue loss transfer? Or is there a better way for carriers to come to us and say, like, this is now the point where I need you to go recover these funds through loss transfer?
Well, I hate to do this. I'm going to steal your own phrase here. Defend from day one, right?
Counter one.
So there's no time like the present. The thing is, the intercompany reimbursement notification form literally has a box that says preliminary or final. And the time to demand loss transfer, I mean, bear in mind you're dealing with a 3-year statute of limitations on the payment, so you got time. But there's absolutely zero reason, whereas with a third-party settlement, you might end up waiting 2 years over the course of litigation. You don't have to wait for any of that with loss transfer. So if it applies, there's zero reason to not serve the intercompany reimbursement notification.
And that's where, like, we work together really well, because it kind of like set you up, like almost like toss it up. It lands on the tee perfectly and you knock it out of the park. Because really what I'm going after is, even a nominal amount incurred by the workers' compensation carrier before we even get to 50, right? Think about a decision from the reimbursing carrier where they are asked to say, here, give me $50,000 or give me $5,000, right? Which are they more likely to just say, here's a check and like get out of the way for the rest of my life, right? They're probably more likely to reimburse you for the smaller amount, the $5,000, right?
And you always have a better chance of getting that because there's no loss transfer reimbursement for speculative payments. That's not covered under no fault. So while we might see a permanency award on the horizon, we can't claim anything until we pay it out. And so as a best practices point, the thing to do is you pay out more in comp, you get a new payment ledger, hit them with the intercompany reimbursement notification. Get that money back as you pay it.
And that's kind of the structure, right? So you get that initial payment back from that first service of the loss transfer recovery request, right? Intercompany. And then every future payment that you make, whether it's an interval or routine status, or even just on a next payment status, you now have this check that they've agreed that you have a right to be reimbursed and say, look, you reimbursed me 6 months ago. I now have this. So like we're not there yet, but here, this is my request. So please filter it in.
Right.
Whereas if you wait for 50, right, or even wait till you have 250 or wait till the third party is settled, right, now it's just another knot that we have to tie when it could be easier to do that in the beginning.
Right, and there's something to also be said for the admission of liability, even if it's implicit in that initial reimbursement. And, you know, some of these companies will think to themselves, we don't want to bicker over $5,000, so here it is, but nothing about this check is to be construed as an admission of liability. And you will see that happen, but the fact of the matter is that when and if it gets to arbitration, you can say, they kind of agreed that this case was subject to loss transfer under either of the provisions, the 6,500 pounds or the livery vehicle. It is something that you can bring up in support of your claim that you've been getting reimbursed for this all along. And it's only now that a scheduled loss of use award showed up and that $30,000 more got dumped into a $15,000 claim that there's an issue with it.
Right, and thinking of it from a bottom line perspective, right? You know, like a checks and balances, or really like a balance sheet, really is the correct term for it. Having early reimbursement on the file actually opens up another bucket of money to play with if you can settle a case, if you can conserve litigation resources, or maybe even add on to more resources, whether they be for litigation on the comp side, maybe with an IME or surveillance. Just playing around with that because you have excess house money to play with is a nicer outcome at the early stage of a workers' comp claim. But I think that's the easy half of it, right? You know, this is the recovery. Let's go get it. Let's get it early. Let's get it often. And let's get it so that you have the money before you make your settlement decision, right? I think the harder push or really question from our clients on loss transfer is when we know that the $50,000 has little exceptions built in so that third-party plaintiff attorneys don't just come and get 50 off the top, right? So take us through maybe one example of something that would be within the first 50K but is still recoverable under Section 29, because that is something that is very, very rarely seen from third-party plaintiffs. They just think we're going to get 50 off the top.
Right. So the instance where this will arise the most often is when you haven't paid 50 yet. Because at a certain point, if you're trying to get to the 50K threshold, you can't on one, you know where I'm going with this, the indemnity up to $2,000 per month. You can't claim that it's what you've paid in excess of $2,000 per month is not in lieu of first-party benefits, but then tack it on to try and reach the 50K threshold. So this really applies principally where there's $50,000 or less paid. But it's an important caveat. So we have, let's say somebody's getting paid, near the maximum total disability, right? They're getting $900 per month. So we have, or $900 per week, right?
Right.
So we have $3,600 being paid monthly in indemnity benefits. First-party benefits and no fault only covers $2,000 per month for the first 3 years following the date of loss. So $2,000 per month, great. You don't have a Section 29 lien on that. But what you do have a Section 29 lien on is the latter $1,600, almost half of the amount for the amounts you've paid in excess of $2,000. And along that same line, really the thing to just keep in mind is One, are your payments in lieu of first-party benefits? Because that's literally the language in Section 29(1)(a). That's where this carve-out is coming from. And two, did it arise from the use or operation, that's one component, of a motor vehicle, that's another component, in the state of New York, that's another component. And if it falls outside of the definition for no-fault coverage or for the first-party benefits, it's not subject to the 50K carve-out.
Right. So let's attack some of those to give really the listener some clear decision-making points here, right? The first thing you mentioned was the $2,000 per month in indemnity benefits or wage replacement, right? So the math behind that is if you have a claimant who has a high average weekly wage that would lead to a rate such as the statutory max rate or maybe even a little lower. You used $900 per week as an example, and it's a round number. You multiply it by 4 weeks in the month to get $3,600 in wage replacement, right? But if no fault law actually carves out $2,000 a month, then what you're saying is that $1,600 is recoverable under Section 29, right? You also said that it's primarily a vehicle to be used for claims where you haven't reached the 50K threshold yet. Can you explain a little bit about that and why that wouldn't apply to a claim that, let's say, has 75K in prior paid?
Well, so it's all about it ends up being the same net result. So this is where we're really going to get into 201, possibly 301 level concepts. But the way to think about it is this: you're going to this third party. You say you've only paid $40,000 in comp, right? The third party attorney goes, "Ha, it's a motor vehicle accident. You don't have a lien. $50,000 carve out. I got you." And you go, "Well, no. This guy was making $3,000 a week. He's getting paid the statutory max, $1,600 or thereabouts per month, is not subject to the carve-out." Well, you cannot, on one hand, say that I have a lien on that $1,600 and then also calculate it, add that number in to calculate when you reach $50,000.
Right.
You're arguing it's not part of first-party benefits and then adding it to the amount of first-party benefits to reach the threshold.
Right.
So it ends up being the same amount in that situation, if that makes any sense.
I think in essence that, let's say you have a 75K prior pay, like the example I gave. If you're able to take out that $1,600 a month, it's just going to be replaced with other monies to get to $50,000.
Right.
Right. Whereas below $50,000, you're getting an efficiency save because it's not being replaced with other monies for the plaintiff's attorney to move up to 50.
Right, because if you think about it conceptually, once if those payments are coming from another source, that $1,600, once you hit $50,000, anything paid over that is Section 29. So it's Section 29 on the $1,600 you're paying in excess of $2,000 per month immediately, or it's Section 29 when you pay over $50,000. But you can't say this is not in lieu of first-party benefits and then add it to your total of first-party benefits to reach the threshold.
Right. And for anyone out there listening that is still, it's a little bit complicated, right? The math and the statute being applied here. If anybody out there has a case where prior pay is under 50K and there's a big loss transfer argument with this scenario applied, meaning more than $2,000 in indemnity benefits paid in a month, let us know. We'll give you the math for your case to make it be understood a lot more easily, because it's not an easy thing. It's rather difficult to understand from a global ad hoc, 30,000 feet above. You really need to actually learn it with a case to make it stick. But as far as your other examples, right? I think the biggest one, in my opinion, is when the motor vehicle accident is outside of New York State, right? So it's very clear cut. We know where the accident takes place. So what happens if third-party plaintiff's attorney comes to me as adjuster, as risk professional, saying your New York comp claim has to take $50,000 off the top of your Section 29 reimbursement, but you find out that the motor vehicle accident took place in Connecticut or New Jersey? What do we do then?
Right. So there's a couple of cases out there on this, and I mentioned it during the inaugural Major Mondays webinar. This is one of my absolute favorites in terms of legal exceptions. You can have a New York claimant, a New York employer, New York third-party defendants, another New York driver as the at-fault driver, a third-party claim in New York. Everything about this could be New York. except for the fact that the accident happened over state lines. And what's great is there's the McHenry case, and then the one that specifically for New Jersey, Ofori versus Green. It literally says New York does not purport to regulate the no-fault laws of another state. So in other words, no fault applies in New York under Article 51 for accidents arising from the use or operation of a motor vehicle in the state of New York. You're outside the state of New York, forget about it. Now, I should be very clear here, that does not mean that the Supreme Court in the third-party action will not adopt another state's analogous no-fault provision and say, well, okay, there is a carve-out under this, so that's going to apply to this settlement. But by and large, it's basically your free ticket out of the $50,000 carve-out. And you will see that very frequently. It seems so cut and dry. There's a New York workers' compensation claim. Everything about it's New York, but the accident happened on the wrong side of the Hollander-Lincoln Tunnel. Very easy way out of the $50K carve-out.
It's a nice little exception because from the comp perspective, when faced with New York or New Jersey, a claimant is going to pick New York, right? Because they can have more control over the medical, the rates of compensation, and the ways to get the compensation are much more lenient and claimant-friendly. So using that leverage to be faced with an opportunity to secure a better bottom line or better recovery in Section 29 negotiation is definitely to our client's benefit. So do you think of anything else? We talked about $2,000 in indemnity per month and an out-of-state motor vehicle accident. Any kind of 201 level issues that maybe you discussed in your webinar that we can flesh out today?
So let's tinker around with the 3-year portion of the indemnity coverage under no fault. So up to $2K per month for not more than 3 years. So here's a good example. You have a 60-something-year-old claimant that twists his knee, and he had osteoarthritis going on beforehand and degenerative conditions, and it's really just an exacerbation. And he's been dealing with the pain his whole life. He files a workers' comp claim, or the employer files a FROI because they have to. And there's this claim going on, and maybe you chuck the guy $5,000 for some initial PT through his employer. Maybe he gets 2 or 3 days off of work. It's not even enough to pass the waiting period. And so you end up with a $5,000 payment ledger for the first 3 years of the claim.
And then comes my slew.
Right, and then all of a sudden he runs into his workers' comp attorney cousin who goes, oh, wait a minute, you hurt your knee and never got anything for it? You should go out there and get a scheduled loss of use award. It doesn't matter that you've now retired. It's literally just, it compensates you for loss of use. It doesn't have anything to do with the timing of when it happened. It's not wage replacement. And so he goes after it, and he goes and gets the scheduled loss of use award. And then you try to assert a lien for that on his third-party settlement. Well, I should say that was a bad example about the twisting the knee. Let's say he injured his knee in a motor vehicle accident, right?
Right. Well, yes.
Yeah. So then let's say he's at the point of this third-party settlement, and you're trying to assert a lien, and they go, well, no, $50,000 carve-out, you don't have a lien here. Well, that scheduled loss of use, which comprises most of what we've paid in workers' comp, say it's a $25,000 slew award, that was paid more than 3 years after the date of loss. So, surprise, surprise, that's not in lieu of first-party benefits, and we have a full Section 29 lien on that $25,000. To be clear, that first $5,000 we paid is still subject to the carve-out.
Right.
But indemnity paid more than 3 years after the date of loss is not in lieu of first-party benefits. The other one, use or operation. That's another interesting one to tinker with sometimes. It can get a little hairy. It can get a little litigious at points. But one of the cases that's out there is a person that dies of heat prostration in their car because the AC wasn't working. And that's not use or operation of a motor vehicle. The fact that he's sitting in a truck when he happens to die, it doesn't subject the claim to no fault. Use of equipment on a truck. For instance, the truck comes with a cherry picker, and it's been parked in the same location for days, and you just happen to swivel the cherry picker to fix something on a telephone pole, and you fall off of it. Yes, it was attached to the truck. Did it have anything to do with use or operation of a motor vehicle? Absolutely not. So That's use or operation is one of the terms you can tinker with. And then I don't want to run on too long, but motor vehicle is another one. Caterpillar and crawler type equipment, not included in the definition. So that's something you'll see with companies on contracting sites. The claimant will try to argue, well, you were driving this backhoe, and therefore it's subject to no fault because it's a motor vehicle. Well, it's not. Neither are motorcycles. So if you have a claimant that's driving a motorcycle in the course of his employment, whenever that situation may arise, and he happens to skid out and get injured, that's not subject to the carve-out.
Good. So I think we've outlined some scenarios here where our clients can really take some value, right? So the idea is loss transfer in two different ways, how it can be used to provide value. One is actually asserting the recovery intercompany loss transfer, right? And we talk about timing in that sense being do it early, do it often. As far as the exceptions to make it Section 29 money, it's really the timing of the payment, right? Are we doing it early enough, and are we below $50K to take advantage of an indemnity benefit? Or are we over a 3-year statute of limitations to now figure out we can now use this from to Section 29 and get a reimbursement that way? And then exception-wise, using legal application of the document to actually bring you back into Section 29, right? So almost like we're carving out of the carve-out.
Right. And this is just to harken back to the prior podcast we did on risk transfer. This is something that you can do from intake. This is something that a competent workers' compensation defense attorney will assess the day they get the file and will keep tabs on, keep their finger on the pulse as the workers' compensation claim develops, and leverage that to a greater reimbursement from the third-party settlement or successful recovery via loss transfer. And if that entails going to arbitration, so be it. That's something we do as a full-service recovery and defense firm.
Well, I think that's a great little wrap-up to today's podcast, right? So for everybody, my name is Christian Cison. For Christopher Major, we're reminding you to defend from day one.